Welcome all. I'm Leah Shanley. I'm one of the two co-chairs or co-chair with George of the Citizen Science Law and Policy Working Group. Delighted to see so many new people on the call today. Today's focus will be on the Aarhus Convention and the possible role of citizen science. Before we talk about that though, I do want to mention we have a webinar coming up the first week in December. And so we'll be sending out an announcement of that with Martin Brocklehurst and Libby Hepburn, and that'll focus on the Global Citizen Science Partnership and the work that they're doing, and Uta Venn, who's on this call too, to build citizen science into the work of the UN Environment Program and UNESCO. So with that, we'll now focus on Aarhus. And the right to environmental information has been recognized in the United States through U.S. environmental statutes dating back to the 1970s, but it's been recognized in the European Union since the beginning of the 1990s. The turning point was the United Nations Economic Commission for Europe's Aarhus Convention, adopted in 1998. The convention is Europe's strongest manifestation of the procedural environmental rights, which are in turn deeply rooted in the right to live in a healthy environment. So I'm very excited today to be introducing to you our two distinguished speakers. And I ask if everybody please mute their computers. We're getting some static noise. So other than the speakers, if you'd please mute until we get to the Q&A session. Thank you. So we have Professor Muki Hakli. He's one of the original founders of the European Citizen Science Association, is now one of the co-chairs. And he's also a professor at University of College London. And then we'd like to also introduce Anna Bertie Suman from Tilburg Institute for Law, Technology and Society. And she also is a new PhD. Yay, exciting. And we're doing some fabulously good work with the JRC Digital Economy Unit. So a lot of the great citizen science reports coming out of there. Anna is one of the lead contributors. Again, I'm still hearing some background static. Andrea, Marta, others who have not muted their phones, please mute your phone or mute your computer while our speakers. So with that, I'll hand it off to Muki and Anna. Whoever would like to, I think, is queued up to go first.
Hello, hi, good evening or good morning, everybody. Yes, I have the pleasure tonight of, let's say, discussing with you the Aarhus Convention or introducing this discussion to you if it's rather new. So I'm calling you tonight from northern Italy. So yeah, apart from being a red zone, it's a beautiful location on the Lake Maggiore. And I'm here as I'm based at the European Commission Joint Research Center, which is the European Commission Scientific Hub, but I'm seconded here by Tilburg University that is based in the Netherlands. So I wear two hats. One is from the Netherlands and the other is from, let's say, Italy or / international. So let me share with you my screen. All right, you should be able to see that. Yes. Okay, and I'll enlarge it so you can see it well. Yes, I see no objection. So as I was saying, so tonight we will talk about Aarhus Convention and citizen science and how the Aarhus Convention can actually ensure the right to environmental information for every citizen, and I would say every, let's say, human being. So I'm talking from the Sensing for Justice project, Sensius in short, which is an individual research project that I'm co-leading with Sven Schade at the JRC. And we are exactly looking at how citizen science evidence and more broadly citizen gathered evidence can be used as a source of argument for environmental law enforcement. And of course, for that, the Aarhus Convention is pivotal. So I will paste later on the website link to our project. But let me start with outlining what I'm going to talk about tonight together with Muhi. So first of all, what is the Aarhus Convention? Second, what are the legal grounds that can be extracted from Aarhus for citizen science? And third, what are the implications for state obligation towards the citizens? And lastly, why Aarhus matters for citizen scientists? So I will use some drawing, and this drawing have been made by an artist. And in this drawing, the artist is Italian, unfortunately, but in this drawing, a sensing citizen says, I'm a journalist, not a terrorist. And this is a powerful statement because in some initiatives that I've been encountered, citizen scientists have been treated like terrorists and not as like healthy sentinels of the system. So, of course, like interrupt me if there's something wrong with what I'm saying or you have a clarification question, but we will keep most of the question to the end. So a step back. Okay, what is citizen science and sensing? Let's say in this framing. Of course, it's a technology. Let's say it uses technologies. It's a social phenomenon. It's a method. But I've been calling it also as a way of expressing rights in actions. So basically, through citizen science practices, we could argue that there are rights that are being mobilized, expressed, and also put forward new rights, as I will tell you later on. First of all, you will see some images, and the images have been taken from Basilicata, which maybe some of you don't know. It's a place in the southern of Italy, it's a region, and it's a big oil extraction hub. And there, what we could call the sensing citizen or the citizen scientist are mostly farmers and breeders and basically normal people that are just dealing every day with environmental contamination, for whom environmental information is a key asset to determine their daily choices. So, why a legal focus is important? So I'm an environmental lawyer. And I do think that what I've been realizing so far that I would, let's say, summarize with a key question is, where are the lawyers? Because in this field, there are really, at least in Europe, let me say that, scarcely environmental lawyers engage with citizen science. There are some, and maybe they're growing, but compared to the, let's say, US side, where I think the discussion among the lawyers have been very much lively and rich, we don't have a similar, let's say, discussion. And second, I think it's really important because I think a potential of citizen science, especially in Europe, has been overlooked, which is the potential of citizen science to be used as a source of evidence in environmental litigation. And I use this picture, which is a Basilicata person, so a person from Basilicata. He's a breeder, and he showed me just a couple of weeks ago a ton of files that are legal proceedings that have been used in this, let's say, litigation. I'm not making names, against an oil company. And he has a strong faith in the legal system. So he saw everything collapsing around him. He saw his river polluted, his animal dying, but still he believes that the legal system, based on the data that he's collecting and collecting also with other volunteers, can bring him justice. So he still have some faith, which I think is amazing because it shows that also the legal system has a responsibility to respond to systemic failure, to the absence of the state in certain circumstances. So I think before going into Aarhus, we need to take a step back. Aarhus is functional to another right. So basically, Aarhus exists because there is another right, that is the right to live in a healthy environment, recognized by Principle 1 of the Stockholm Declaration 1972 from the United Nations Conference on the Human Environment. And so according to this right, every human being has the right to be to live in an environment of quality that permits a life in dignity and well-being. So there have been multiple interpretations, but European Courts of Human Rights, the Inter-American Court of Human Rights, based both on the European Charter of Human Rights and the American Charter of Human Rights. Many constitutions in every state have been very creative in adapting this right. For example, in Norway, in the Norwegian constitution, there is this right, but also, for example, in Japan, there is the right to happiness and to sunlight that was derived from the right to live in a healthy environment. So this right implies a duty of government, but also a responsibility of citizens and communities to act upon situation where this right is under threat or completely breached. This right is fundamental as, let's say, as a premise. So in order to be enforced, you need to know about the status of your own environment. So this is where the Aarhus Convention plays a role. So the Aarhus Convention is a, let's say, primarily European instrument. And with European instrument, I also include, of course, Russia, for example, as comes from the United Nations Economic Commission for Europe and is the Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters. So 3 pillars. First, the premise, the right to live in a healthy environment. So in order to contribute to the preservation of this right, each citizen and interested actors have 3 rights. One, so the first is to access environmental information. The second is to participate in decisions affecting your own surrounding environment. And third, access to justice in environmental matters for the citizens if this right is denied. So for example, information is not shared with me, interested citizen, or NGOs and associations that are per se bringing an environmental interest. So 3 pillars. The Aarhus Convention was implemented in Europe through a number of EU directives, through the jurisprudence of the European Court of Human Rights, and interpretation by the Court of Justice. And of course, also in the inter-American system, the American Charter of Human Rights kind of adopted the convention and translated it to the American context. What is important here is to reflect on the breadth of this obligation, because it's pretty broad. So Muke will tell you more about the electronic information tools, but in a sense, it could include data, and it does, data fed by the citizen. And I will show you more through a sort of step-by-step logic reasoning. What is also important is that it's important that not only information is given, but that due account is given to the information, that to the participation provided by the public, and so also the information that the public is providing to these participation channels. And there are a number of indirect obligations for the state. For example, not only to provide information, but also to provide it in an accurate way, in an accessible manner, in an understandable manner, and so on. So let me do a sort of step-by-step. So Article 4.1 and 4.2 says information that is held by public authorities. So basically, only information that is in the hands of public authorities is covered by the Aarhus Convention. But at the same time, authorities should make all effort needed to gather accurate and detailed information and disseminate them. So in a sense, you would say that we could say that in a situation where the authorities lack this information or don't have accurate information, there may be a duty to consider and disseminate the information provided by the citizen because they feel this sort of obligation by the state. Of course, this is not what, so the convention doesn't say that explicitly, but I think through a sort of logic step, we could reach this argument. And in also this sort of right to access to justice in case your request to access information is not adequately answered, Article 9.1 also implicitly says that this information should be provided adequately. So basically, institutions should take all measures necessary to inform the public properly. And thus, if the citizen sends data, the citizen-generated data, can contribute and make this information stronger, then the obligation of the state to provide adequate information gets also complemented by a sort of additional data flow. So let me say that also there is a protocol, the Kyiv Protocol on Pollutant Release and Transfer Register, that's from 2006, that complements the Aarhus Convention, and it does require private companies to submit this register of pollutants that they release in the atmosphere. But but this protocol also allows for public participation. So I reached the secretariat of the Aarhus Convention, and they did said that actually they could be open to citizen science data or citizen generated data input for the protocol, but just that so far it didn't take place. So it's interesting because the protocol secretariat said, well, this is an avenue, we just didn't explore that. So let's say all these points made me posit that a right to contribute to environmental information could be extracted as a sort of fourth Aarhus pillar. And I will post more evidence on that later on in the chat. So these two rights, which are kind of mobilized through citizen science, could also be strengthened by other rights, such as the right to science and freedom of information rights. And I think we could talk about that forever, but I would just keep it like that. I think that Aarhus matters for the risk that citizen scientists incur when they monitor, especially in situations where, for example, oil companies are protected by mafia, such as in certain southern regions, or and southern, I meant the south of the north. So for example, southern Italy, I'm not going that far. And of course, we had experience, for example, the Wyoming case of criminalization of the citizen scientist. And for example, in the US, you know well more than me, the strategic lawsuit against public participation that were often targeting activists, and why not, they could target citizen scientists, and they already did. So of course, having a right to contribute to environmental information would very much shield these participants from adverse legal claims. Second, so this is more defensive, more proactive. I think it would be a great normative argument that would persuade authorities to listen to this data. Because one thing is to say, this is important information. One thing is to say, it's my right that you listen to me because this is my right to contribute. It would have a tremendous disruptive power. And all these images I would comment if I would have more time are taken from Basilicata. So here, for example, there was a chemical storage facility, and the activists were taking pictures, and the police, like the public police, stopped them and made a recording of their actions, and they were on public land. So they were on public land taking picture on private side. And so I think the question on input legitimacy, who is legitimate to provide input on environmental information, is very much open and really need to be answered also from environmental lawyers. And with that, I would leave it with this picture where a number of sensing citizens in Basilicata were listening to a farmer. And maybe what I got from that experience there is that probably the kind of the most genuine sensing citizen is actually the normal farmer, the normal breeder that is just caring about their own land and need to demonstrate what's going on for their daily life. They don't need some overarching activist agenda. They just need a tool to be legitimized in doing what they daily do and for facing eventual risks that in monitoring they could incur. And I think it's our responsibility from the environmental law perspective to give to these citizens all these tools that they would need to stand in front of authority, in front of the police, in front of the private actor to say what I'm doing is not only right is also legitimate, it's my right, and so on. So as you can see, I'm really passionate about that, but I think it's good to pass the word to Muki, who also has a great story to share. Thank you.
Thank you, Anna. And Muki, if you would share your slides. I think you have to unmute yourself as well.
Yeah, I should. Thank you.
Okay.
So let me now share and start the slides also. So just as a background while that starts, it's also valuable to remember the geopolitical context of Aarhus, because it's really interesting. It's a very fortunate convention that came out of the end of the Cold War. So the discussion about the origin of it, this concept of the three pillars of environmental democracy, access to information, participation in decision making, and access to justice, was raised as one of the principles of the Rio Conference in 1992. And then a whole set of environmental organizations and interested parties and countries, especially from Scandinavia, kind of created the momentum to set out the convention. And it is noticeable that it was done with UNECE and not with the European Commission. And when you talk with the people behind it, they deliberately didn't want the union to take over it, but actually to make it into a UN one. And that enabled it to reach out to post-Soviet countries. So one of the fascinating aspects of it is that it's an environmental convention that actually cover a lot of Central Asia countries, and it's bridging both the European Union and what the European Union call new neighbors. So down to Armenia, Georgia, and other countries. And if you look at the convention and the website, you will see that the material is regularly published in Russian in order to reach those communities. And that's one of the kind of geopolitical aspects of it. There are also a whole network of Aarhus centers that are funded by the Organization for Economic and Security Cooperation, which are also providing this access to this environmental democracy. There is, before I'll progress, there is actually one oddity that always was noticeable for me. So for me, just like what Anna said, I'm very passionate about it, basically because it is the center of my work since my PhD. I've started my PhD in 1997, and then Aarhus came along in 1998 and completely directed what I was looking at, and it's actually central to a lot of the work that I'm doing, even if it's just as an infrastructure. So that's where also the oddity, because apart from other interesting aspects of it, there is the order of things. So the fact that you are actually calling for first to public access to environmental information before you ask for participation in decision making or access to justice is a really interesting aspect of environmental decision making. It makes sense exactly because in environmental decision making, the decision making is very scientific and relying on a lot of environmental information. There is a whole issue about how you define it, but what is interesting is that without the access to information, there is no point in participation in decision making. You won't be listened to. And that is an ongoing problem that we're seeing also with, say, tribal knowledge or local knowledge or other types of knowledge, which for a very long time, even again, though they were mentioned back in Rio conference, they were continuously ignored. They're not being respected in different ways. So those are the kind of aspects, and it's an interesting piece that although it's not very strong, it did a lot of influence and it did change practices across government. Now, within the convention, there is this interesting line that you see along on the screen. And in 1998, they wrote, each party shall ensure that environmental information progressively become available in electronic database which are easily accessible to the public through public telecommunication networks and not the internet or the web. The reason for that is that actually was the case of the environmental organizations, which have a very important role as stakeholders in were putting together, and they had much more knowledge than the government officials. You can imagine what the different government officials from the post-Soviet countries knew, but that was also even
Mookie, this
which
is
it
Leah.
didn't
You
have
may turn
before
off
that.
your video because you're freezing up if you want to increase your bandwidth.
Oh, sorry. So I'll turn off my video. Thanks. So let me do that. Okay, so let's leave just the point. So I hope that now you can hear me better. So as a result of this interest in provision of electronic information and the commitment of the parties to put it together, there was an whole issue of how that it's going to be implemented. And it took between 1998 to 2005 when a recommendation on electronic information tools were established. And now, after about 15 years, there was time, of course, to update them with all the changes in technology. And that provided an opportunity to get involved in the process and offer elements of citizen science. So there was both an interest in including this information, citizen science in that. And then what we have done is a group within the European Citizen Science Association got together, including me, Anna, Leah, and others, which are listed on the first page. And we looked through the recommendation and we suggested different things that should change in the recommendation, in the updated recommendation. And that will influence both the practice within the convention, but importantly, there is already one similar convention or agreement in Latin America, in the Caribbean, the Escazú Convention, and also it can influence other processes within the UN, so it was worth doing that. So for example, we suggested, we pointed that citizen science should be an open definition, and you'll see the definition later on. We also added the whole issue of open science in order to make the link between environmental information and other elements of open science. So Uta is, for example, on this call, and there is the whole effort of the global partnership to work with UNESCO on open science. So that is valuable. And there was an element of open by default of governmental information, which is very important. But when it comes to vulnerable community activists, environmental campaigners, we should be careful of not demanding of them to go with open by default. So that's something that we're pointing out. There is, for example, a specific paragraph that is dedicated to citizen science, and it's worth looking at it. And our changes actually mostly were accepted by the Secretariat. And they are actually calling the different parties of the convention, which are 46 countries, to promote the use of citizen science, crowdsourcing, and local and indigenous knowledge through electronic information, and then talking about how it's going to be used in different cases. There was also different places where we included, for example, I won't go through each of the bits that we changed. I can share with you the information and I will share with you that the link to that. But for example, we made sure that platforms that are common in citizen science or participatory mapping, crowdsourcing and citizen science platform are listed as enabling tools. And also the low cost and mobile sensors are also noted in as part of the places for data creation. What we also done is recommended that in the area of engagement with the public, there will be, so they picked up the term citizen science observatories, not just citizens observatories, but we also pointed out that there should be project and other participatory initiatives. And also we took out an element of pointing that there should be integration of such data with traditional form of environmental data, because we know that lots of time it's being kept separately and there is no special effort of using the citizen science data. And then also we copied from another element of the recommendation on the use of tools to recommend the use of apps and technologies for data collection. Then something that might influence other things within the UN, because now there is a process where between UN branches there is sharing of terminology. We made sure that we included a concept like Open Science Initiative, where we took the terminology from OECD. We took the citizen science definition that was used by the Secretariat, which was actually based on the Oxford English Dictionary, but we added engineering research because it's so critical to the field of environmental observation. We took from the We Observe project the term for citizen science observatories, so that will be included in the system. We also made sure that participatory mapping is included, and the concept of datathons and hackathons. So they are also something that is opening up to civil society organizations as activities that can be facilitated by governmental bodies. So for example, hackathons were already mentioned and inserted probably by the Commission or by different environmental organizations. And we added to it in the field of environmental information, the datathons, because we've seen that also at the very beginning of the Trump administration, when there was a whole gathering to deal with access to data. So those changes, both of them, all the changes that you see here actually been accepted by different bodies. We also included definitions for what is citizen science data and what is citizen generated data. I don't want to go through each of these things. So it was a really fast collaboration of a relatively small group of people. We also early next week, we are going to present those changes to to all the members and the parties. There is actually a meeting of the task force that is happening next week. And from looking at the new draft of the recommendation, a lot of the changes that we asked for were accepted. So we have made a difference to the way that those recommendations are evolving. And it might open up, again, because of the reach of the convention, all kind of opportunities to start collaborating with countries in Central Asia. So that's me. Thank you.
Thank you, both of you. And Mookie, you can try putting on your video again. It'll work. So we'll open it up to questions. I don't necessarily see any questions coming through on the chat box, but I'll ask a starter question and hopefully folks in the audience will have questions. If you put it in the chat, sorry?
Uta got her hands
Oh, she's
up.
got her hands up. Okay, I'll look on the, there we go. Thank you. I'll put it. So I'll call on Uta first. Yeah, so if folks, if you click on participant icon on the bottom of your screen, that'll take you to the list of participants. And there you should be able to raise your hand. There's a little blue hand that says raise hand. If you click on that, hopefully I'll see it and call on you and you can ask your question. So Uta?
Well, actually it was a mistake. So I'll stand back. I'll figure out how to take my hand down again. I'm sorry.
Oh, no worries. Okay, well then I'll ask a first question while we wait for others to raise their hand. So Anna, being a lawyer by training in addition to a PhD, you've looked at this context of Aarhus in Europe and in is it Southeast Asia where this applies. In the US, here in, we've been dealing with issues, as you referenced in your talk, related to the ability to collect environmental information in Wyoming and in Texas. So it's kind of First Amendment concerns. Can you maybe comment on comparison to the US context where you have the First Amendment rights and the Freedom of Information Act, which allows access to government information, and the Aarhus?
Yes, thank you, Leah. Great points. So I think one of the aspects that I noticed, especially if I would compare US to Europe first, because I think I cannot compare, like, let me do one and one and then Southeast Asia, because I think it's largely incredibly different. I would say that I've heard way more referencing to freedom of information and freedom of expression in the US compared to Europe. So I feel that this idea of the First Amendment and it's really more entrenched that what we have in Europe, although our constitutions do recognize these rights. So I can mention the Italian constitutions and the Dutch constitution and some other, well, most of constitution around Europe, they have it. But in a sense, it's less used in connection to citizen science, which for me is striking because, I mean, many times I see that the problem is about freedom of expression. It's really even not yet Aarhus. And I think having Aarhus often brings it's the most used by environmental movements, whereas I would feel that actually the freedom of information and freedom of expression should be used way more also here. I do have also the impression that over there in the US, it's not an impression, it's actually a fact. You have way more the culture of litigation and of using acts for litigating. And here I feel, in a sense, Aarhus was used for litigations, but really scarcely in relation to citizen gathered data. So I think here is a large potential. If we would move to context such as Southeast Asia, there I also looked at how information was dealt with and which kind of rights, also in terms of access to evidence, were, let's say, recognized there. I felt that there the role of right to information was really about shielding participants, because it's really there it was about activists at risk. And there I realized that the role of NGOs, so kind of medium up, what I call this medium up, so filters between the government or the private actor and the citizen, was essential to voice these claims. So voice claims to right to information or freedom of expression, because the people themselves and the participants were really much at risk. And so, for example, organizations like Greenpeace were very much steward of these rights, so like channeling them. So in a sense, I think it's a very, I would say there's a potential also over here, because I see way more, for example, in Europe, way more discussion on silencing journalists and so on, but I think it will grow in the coming years. So that would be my thought.
Wonderful. I see Mookie has his hand raised.
No.
No? Okay. All right. Well, I see we have another question. Well, George Wyeth. George, did you want to add something to what Anna has shared?
Yeah, I thought I would just jump in on that question about the contrast between Europe and the US, because that was pretty pretty fascinating, and I certainly can't go into it any near the depth that Anna did. And I don't claim to be a real comprehensive expert on U.S. information law. Sean Goho or Ethan McMahon were on the call, may have things to add. I guess so I was kind of dividing it into the right to submit information to the government, which is pretty clearly, very strongly protected both by the First Amendment and by our administrative law statute, which has been around since the 1940s. Then there's the right to have information considered and a response of some kind, where again, we have pretty good legal authority. There's the right to obtain information from the government, which is where FOIA comes in, the Freedom of Information Act. And then the last piece that you mentioned, and this is where I don't think we go very far, is a right to have information then disseminated by the government. I'm not really aware of that. I mean, certainly information could be submitted in connection with a rule or a permit proceeding, and it would become part of a public record. But there is, I think, very little right for someone to compel the government to re-share information. If anything, there's a law that kind of ties the government's hands or creates extra hurdles if the government is going to re-disseminate information from an outside source to make sure that that information is valid. So with us, it's much more of a kind of a patchwork, and we're kind of piecing together things, most of which have been around for 50 years, and we're now applying them to very different situations. So anyway, that's the extent of my thought, but I would definitely invite Sean or Ethan or others to add to what I said and even correct me.
Yeah, the one caveat I might add to what you're suggesting, George, is distinguishing between federal law, like national law,
Right.
and law down at the state levels, because there are states like Texas and Wyoming that have prevented, you talk about the right to submit to the government, but they explicitly don't allow folks to take pictures of, say, or submit information about private land to the government. And actually Wisconsin did that as well, limited it to some of the endangered species data. They weren't. So anyway, I hear, was it Ethan wanted to jump in and say something particularly about open data?
George pulled me in, so yes, I'm in. All right. So yes, I thought it was helpful to hear Muki's kind of talk about keeping tribal and community data private at sometimes, and as opposed to being open. I think that I was trying to give some context in the comments that this open data movement was originally, as far as I know, meant for governmental agencies to make their data public. So the public would know what data that government is collecting, and they would also know who is providing political contributions to candidates. So it was like to open up the government operations so citizens would know if there were forces affecting policy that were based on money, for instance, and the data about who gave the money. But that evolved into making all federal government open. And I just put in the chat a link to a discussion about the United States Open Data Act, which passed around in 2017. You can read a little description and the link I put in there. But I think Muki's talk about this evolving. So tribes and communities can keep their data private if they'd like. I think that's a healthy thing.
So in the US, there is no tribal exemption under the Freedom of Information Act, and that has been contested in court and has gone all the way up to the Supreme Court. Joseph Robertson's on the line here. Joseph, do you want to comment at all on Indigenous data sovereignty in the context of environmental information?
Yeah. Good morning or good afternoon or good evening to everyone. My name is Dr. Joseph Robertson. I'm the chief data scientist of Mato Hitika Analytics LLC here in the United States. I am currently working on smart solutions for tribal communities, and I based my doctoral dissertation on understanding how to create a data science framework to assert tribal sovereignty using the principles of data sovereignty. And one of the reasons that that Dr. Shanley and I have connected is I used a portion of her work that involved looking at tribal spatial data sovereignty and the implications of federal Indian law and case law and how that applies in this context. I think we're talking about one of the ideas in my particular work in my dissertation. I actually did cite the European Citizen Science Association and the 10 guiding principles of citizen science. And what I was doing and what I'm doing now is trying to contextualize the idea of bridging science and culture. And how do you understand that in the context of, I guess, the democratization of data, as well as understanding this idea behind this environmental movement, and how do you create a convention that, you know, applies in different contexts. In particular, some of the work that I've been doing right now is working with tribal communities here in South Dakota to understand the fight against the Keystone XL pipeline, and understanding that how do you create and fight against a system that has all of these implications that Dr. Shanley has mentioned, that we have federal Indian Supreme Court case precedents that American Indian tribes as domestic dependent nations, they have very specific sets of rules that we have to follow, and that we're guided by those decisions. And so the tribal government's position is not always the best in certain situations, especially dealing with federal agencies. And I think Ethan had mentioned something about open data, and this data sovereignty, the indigenous data sovereignty idea that I have put forward and that many other American Indian groups are doing now, is to how do you assert data sovereignty in a context that provides the community a benefit. Like I said, right now, as I'm working towards working at fighting the Keystone Pipeline, I'm designing smart solutions specifically for these purposes. And so, for instance, currently right now, I have had to figure out how to not only create a company that I can do this with, but I've paired it with a nonprofit that I've also started to create citizen science education that's paired with the actual application of these ideas. So for instance, right now we're working on strategic GIS mapping on certain parts of where the corridor of the Keystone Pipeline will go through certain tribal areas, and to create water sampling plans and water testing plans that can be shared with other indigenous groups or any tribal groups or any interested citizens of being able to assert this data sovereignty and to get ownership of this data, because it's not always available to indigenous people or to people that are in underrepresented communities. So that's essentially, my comment is that I'm working on the ground level right now with grassroots Native organizations to do this work. And it's a very, very specific set of citizen science rules that we're trying to establish here in our communities so that the community benefits from this work. So thank you.
Wonderful. Thank you, Dr. Robertson. Really appreciate your comments. I've got two more questions in the queue before we wrap up. Melgorzada has been waiting very patiently with her question. If she'd like to jump in, and then Liz has asked a question.
Hi, hello. My name is Margaret. It's, well, easier to pronounce. Thank you, Leah.
Sorry.
I'm from Poland, and just want to make a very short comment on that what Muki raised, that Aarhus Convention was like a kind of wow for Central and Eastern Europe. Here in Poland, it was like a majority of you from Europe know it, that we've got like a complete block to any kind of environmental information, right? And although Aarhus was established on 1998, right? Am I correct? Or 89? I don't remember.
Yes,
And
98.
98, okay. Poland ratified it a few years later, like 2003. But anyhow, even it was like, let's say, in already democratic country, we still had problems with an access to the environment on to the information on environment. So really, it was something that the government was obliged to give an open access. That's one thing. And the second thing is that this is also probably more familiar to the European people, that we've got like a big network of protected areas called Natura. There was a lot of protest and then negotiations on where to establish Natura sites. Again, Aarhus Convention helped a lot, not only to the citizen science activists, but to those who they could have been advocated for, like private owners of the land. So thank you very much for showing what the Aarhus is. In case of Poland and other countries from Central Europe, probably something different than to the rest of EU 15 and the States. Thank you.
Thank you. And then Liz, you had a question for Muki and Anna on their vision for the Aarhus and the role of citizen science going forward.
Yes, I'd love to hear if you could spin out a little bit more broadly what your vision may be that inspires you to have all these multiple ways of knowing start to count inside of science. And I'm just asking, some of you may know the public laboratory works extensively on cultivating a grassroots inquiry, out of which some very pointed pieces of environmental evidence may lead to different kinds of regulatory or legal action. But it's out of a pool of inquiry that science is often rejected. So my question here is, with so much participation being shoehorned into a science as a kind of a reform move, a science which has failed to protect people from the applications of science, like at a scale that we now have climate change, what's the vision of this kind of reform to science to have more ways of knowing count after having excluded them for so long? We have a planetary crisis. Thank you.
So great and big question, but I'll give my bit, and Anna actually covered it. It's something that you think about it. So for those 30 years, the concept of environmental democracy is something that coming from the government to the citizen. So notice access to environmental information that is held by the public, by public authorities, participation in decision-making, which is the power of the authority to do it, and then redress it through access to justice. By sneaking in the right to produce environmental information, you're actually creating a very, very different right. It comes with obligation. It comes with complications of what exactly it means to produce information and the obligation to produce good information and all the rest of it. So it shouldn't be approached lightly, but once it's there, it's actually changing the whole way in which people relate to processes of environmental decision making. So that's my take on it. And it's kind of something that I want to see being pushed, that something is missing with these 3 environmental rights, and we need the 4th one.
Yeah, as Muki, I fully agree. And maybe just, I think connecting what Liz just said with what George was mentioning before, I would say that a big difference between kind of giving information to the citizen when they ask it compared to disseminate actively information and eventually include also citizen complemented information is that in one case you solve kind of case by case the need for information. In the other case, with a sort of change of paradigm from putting information on demand to putting information on offer, you basically put the scrutiny like by default. So basically the default, as also Ethan was saying before, like the openness of environmental data from institutions, of course, when it doesn't breach any indigenous for example, rights, of course, so with all the preservation that are needed there, I think changes the paradigm, because I think the only thing that you need when you need to ask and go through a long process to get this information, you're already disincentivized. Whereas I think the change in paradigm is if information is disseminated as much as possible and all the streams are gathered together, and this is like the default, I already think that a systemic change is ongoing. Then I fully agree with you that it may be too late, or it depends on how optimistic are you. I do think that anyway, the fact of having a right changes the discourse. I think it's really different from saying I'm doing something good from I'm doing something because it's my right. It changed a lot, especially when you then have to go to court and say something there. So I do think that maybe we did a lot wrong in the past, but then let's say it's never too late.
So thank you, Anna, and thank you, Muki. People are beginning to drop off now because we're at the top of the hour. Outstanding presentations. Before we go, I want to mention two things. First, our next Citizen Science Association Law and Policy Working Group's webinar, which will be more of a public activity, will be held in early December, December 3rd, 3 p.m. US time, which is a bit late in Europe, but we've got a Martin Brocklehurst from London and Libby Hepburn from Australia, so we're having to accommodate the time zone in Australia. So that will be December 3rd in US time, December 4th in Sydney time. And then in January, I'm in the process of organizing a webinar for the working group on citizen science and Indigenous communities, and particularly with a look at Indigenous data sovereignty. So stay tuned for that. And George, any last comments as we close?
No, I'm good. That's great. Great presentations, great discussion.
Yes, and thank you all for joining us. And Muki and Anna, keep us posted on progress. Maybe we'll have you debrief us after the sessions next week with the UN. Thank you all.